2017-63, State of Arkansas versus Ashley Wenzel, domestic battery in the second degree. Once again, the Public Defender's Office has been appointed. Is that correct? This is one that hasn't been? Okay. Ms. Wenzel, have you made any arrangements for an attorney at this point?
Your Honor, she visited with me by
Ms.
Skype.
Wenzel, can you hear the court?
Yes.
Okay. All right. And I can hear you, so I just wanted to make sure of that. Have you made any application to the Public Defender's Office or tried to secure an attorney?
I talked to somebody yesterday briefly, but all we talked about was the bond amount.
All you talked about was what?
All we talked about was he said he was going to get the bond lowered, and that's the only thing he told me.
And who was this?
That was me, Judge.
Oh,
She talked to me by Skype.
okay. All right.
And I also instructed her if she wanted our services that she needed to fill out the application.
Okay. What you need to do is get a copy of an application for the Public Defender's Office. They're available there at the jail. You need to ask the jail personnel to provide you with one. Get that filled out and signed and turned in, because that's how you secure appointed counsel.
Okay.
You have the alternative of hiring the attorney of your choice, and the court doesn't get involved in it if you're going to hire private counsel. But if you're looking for publicly appointed counsel, you have to fill out that application. All right? You understand?
Okay.
All right. So at this point, the record, I'm just going to reflect it. As I understand it, you're going to apply. This case, on the charges in this case of domestic battering in the second degree, Class C felony, endangering the welfare of a minor, 2 counts, a Class D felony. On those charges, how do you now plead?
Your Honor, she talked to me enough. I don't want her to prejudice herself. She
All right.
wants to enter a plea of not guilty.
I'll enter a plea of not guilty. Court will plea of not guilty. I believe the January 24th is the arrest date, and the court is going to put the apparently bond was initially set at $5,000.
Your Honor, what she told me yesterday is that she is 23 years old. She indicated to me that she has no criminal history. She indicated that she can live with her grandmother, Debbie Martin, at 1508 Hallmark Circle in Mountain Home. And based upon that, I did inform her that I would ask the court to reduce her bond. I would ask the court.
Given the nature of the charges and at least the behavior described in the affidavit, the court has some concern if that's an adequate bond. Even the $5,000 is adequate. This is I understand the circumstances which the officers went to the home, but the court's concern is that this person, at least in that condition, was a threat to other people. What says the state?
You know, the state's position is that this bond is appropriate, does not need to be reduced. This could have been a whole lot worse than what it was, and we are just concerned that the violence that was inflicted is not under control at this time, Your Honor.
All right. Well, I'm going to set the bond at $5,000. I'm going to condition that bond on no use of drugs or alcohol, and I don't know what prescription substances were involved, but at this point, the condition of the bond is there'll be no use of any type of drugs or alcohol. If she's in need of prescription drugs, she needs to see a physician before she.
There's also a no contact order from district court in this case. We'd ask that no contact order be remain in place, Your Honor.
And that was the third thing I was going to say, is there needs to be a third condition, which is that she have no contact with the alleged victims in this case. All right, that'll be the order of the court. The court is setting this down for reappearance in front of Judge Putman on February 2nd. You may be excused.